Okay, let's unpack this. Today we're taking a deep dive into, well, the whole evolving landscape of digital data privacy. We're really zeroing in on India's landmark legislation,
Oh,
the Digital Personal Data Protection Act, or DPDP Act, from 2023. And our main source for this, our guide really, is a very practical compliance checklist for Indian businesses.
yeah, and what's fascinating here is that the DPDP Act, which came into effect back in August 2023, it's a real game changer. It fundamentally regulates how digital personal data gets collected, processed, and stored right across India. You can see it draws some inspiration from frameworks like the EU's GDPR. That signals a kind of global move and now India's firm commitment to prioritizing privacy. So our mission today for this deep dive is basically to pull out the most critical, actionable insights from this checklist. We want to make it clear, make it practical for you, the listener. Doesn't matter if you're a business owner trying to figure this out or maybe just curious about your own data rights.
Absolutely. So for any business, really, digital or not, that deals with customer information. Something like the very first step now is just getting your house in order, right? The checklist starts right off with data inventory and mapping. What does that actually mean for a business? Why is it like the bedrock?
Well, if we connect this to the bigger picture, it's not just some regulatory chore, it's actually strategic. Data inventory means figuring out every single piece of personal data you're collecting. Names, emails, maybe even sensitive stuff like biometrics, financial details. Then you have to classify it. How sensitive is it? What's the exact purpose you're collecting it for? But the mapping part is critical data mapping, literally tracing where that data goes. Does it move across your internal systems, third-party apps, cloud vendors, maybe even across borders, knowing your data inside out? Well, it's like getting your business's digital DNA sequence. It shows you where you're vulnerable, but maybe also where there are opportunities for using data ethically.
Okay, so mapping that whole journey, collection to
Yeah.
wherever it ends up, makes sense. And once you've got that clear picture, that map, the next logical step, I guess, is telling people about it, the individuals whose data you actually hold. Which brings us neatly to update privacy notices.
Exactly. The Act is very clear. Businesses need clear, concise, easily accessible privacy policies. These aren't just legal text anymore. They really have to spell out what data is collected, the specific reason for collecting it, and crucially, how long you plan to keep it. And it's also vital they provide clear contact details for grievances or for a data protection officer, a DPO, if the company needs one. Transparency is the goal here, so individuals, so you, understand how your information is being handled.
Right. Now, here's where it gets really interesting, I think. We're shifting to what feels like the absolute core of data protection. Obtain valid consent.
Mhm.
Sounds simple, but I bet there's some major nuances here. Maybe even a cultural shift involved.
Oh, absolutely. There are definitely nuances, and this is where you see that rebalancing of power between the individual, the data principal, and the business. It's quite profound. The Act says consent must be freely given, informed, specific, and unambiguous. Yeah. So no more of those sneaky pre-check boxes,
Yeah.
or toggles hidden away somewhere. Users have to actively opt in. A good example from the source is making sure you use checkboxes or toggles that are not pre-selected. It's an active choice. This signals that businesses really have to earn trust and keep earning it. And just as important, the Act insists on an easy way for users to pull back their consent anytime. Depending on your scale, how complex things are, you might even need a dedicated consent manager tool or person to handle all this efficiently. It really is a cultural shift, not just legal.
So not just getting consent once, but like you said, continuously earning and keeping that trust. And once you have that consent properly earned, the Act ensures individuals keep control. That leads us to honor data principal rights.
Yeah, and this raises an important question about, well, individual agency, doesn't it? The DPDP Act gives several key rights to individuals' data principals, as the Act calls them, basically the owners of the data. These rights include accessing their own data, asking for corrections if it's wrong, asking for deletion, and generally understanding how their data is used and shared. For businesses, this means you absolutely need robust, responsive systems. You've got to handle these requests properly within a reasonable time frame. It's a big shift, truly empowering you, the individual, giving you more control over your digital self.
That makes perfect sense. Okay, so individual rights are clear. The next big question for businesses is, how do you structure things internally to actually do this consistently? Which brings us to appoint key roles.
Right. This is all about accountability, making sure someone is responsible. For what they call significant data fiduciaries, think larger companies or ones handling lots of sensitive data, appointing a dedicated data protection officer, a DPO, is mandatory. For smaller outfits, it might just mean assigning someone internally as the compliance point person. But regardless of size, the key thing is clearly defining who's responsible for what. Handling complaints, managing consent withdrawal requests, and importantly, reporting any data breaches. Everyone needs to know their part in protecting data.
And beyond the people, you've got the tech side, the safeguards. The checklist really hammers home the need to implement data security measures.
Absolutely vital. And this directly helps you, the person whose data is out there. The checklist points to essential security measures, things like encrypting sensitive data or maybe pseudonymizing it. Pseudonymizing basically means changing the data so it doesn't directly identify someone without extra info kept separately. It adds a really good privacy layer, but you can still do analysis on the data in aggregate. The list also includes robust firewalls, strict access controls, secure storage, the works. But it's not just setting it up. There's a strong push for continuous monitoring, watching for any unauthorized access or misuse, and doing regular security audits. Keep those digital walls strong.
And if, despite all those defenses, a breach does happen because, let's face it, nothing's ever 100% foolproof. The checklist talks about needing to establish breach notification protocol.
Yeah, that's a critical three-part plan for when things go wrong. First, businesses need a clear process to spot and properly assess data breaches, fast, as soon as they happen. Second, if there is a breach, there's a strict rule. Notify the Data Protection Board of India promptly. And third, just as crucial for rebuilding trust, you have to inform the affected users. Promptly, transparently. Transparency, even when it's bad news, is absolutely key.
Right. It sounds like a ton of groundwork. But then how does a business make sure this isn't just a one-off setup? How do they keep it going? The Act seems to really push for ongoing vigilance, starting with conduct DPIAs if required. What exactly are data protection impact assessments, DPIAs, and when are they needed?
Good question. Think of DPIAs as a kind of privacy risk check you do before you launch something new or start a new high-risk data activity. They're necessary when you're dealing with things like, say, processing large amounts of health data or using AI with personal data or doing extensive profiling. High-risk stuff. These assessments help you spot and figure out how to reduce potential privacy problems before they become real issues. And of course, you have to keep detailed records. Document the DPIA itself, document the steps you took to mitigate risks. It shows you've thought ahead.
Okay. And like any big operational change, it's not just about the systems, it's about the people, isn't it? The checklist makes a point about the mandatory need to train employees.
Yes, absolutely mandatory, and it just makes sense. Any employee who touches personal data needs regular training on DPDP compliance. This means teaching staff how to handle data properly, reinforcing security rules, making sure they understand consent. It also means setting up clear ways for them to report any suspected data misuse or complaints they might hear about. For you, the individual, this means the people handling your data should be trained to do it responsibly. Everyone in the company plays a role in protecting your info.
And the last core step here seems to be maintain documentation and audit trails. Sounds like the show your work part.
Precisely. That's a great way to put it. It's all about accountability, being able to prove you're doing things right. Businesses must keep thorough records of all their data processing. This includes logging user requests, keeping clear consent records, documenting any breaches that happen, and detailing how they fix things. The idea is to always be audit ready if the Data Protection Board comes knocking. Is your paper trail proving good data hygiene?
Got it. And as a little extra, the source material gives some ongoing compliance tips. What are those practices for staying vigilant beyond just checking the boxes?
Yeah, they really drive home that compliance isn't a one-and-done thing. It's an ongoing commitment. It evolves. The tips include reviewing your policies and procedures regularly, say every 6 to 12 months. That's important as your business changes, technology changes. It also says stay updated on guidelines from MeitY. That's the Ministry of Electronics and Information Technology and Digital India stuff. You also need to keep checking on your third-party processors. Make sure they're compliant because often your data goes outside your direct control. And finally, just keep an eye on legal updates, amendments, new rules related to the Act. It's a living thing, a continuous process.
So what does this all mean then? The DPDP Act 2023, it's clearly a huge step, a really necessary step for data privacy in India. It's fundamentally changing the digital landscape. It demands a proactive, really holistic approach from businesses. Everything from, like you said, mapping your data's DNA to making sure every single employee is part of the solution. And for you, the individual listener, it means stronger protections, definitely more control over your personal information.
Right. And if we connect this to the bigger picture, Maybe think about this. How might this increased focus on data protection actually reshape consumer trust? And maybe even digital innovation in India over the next few years. What new expectations might you as an individual start having for the businesses you deal with? And maybe how could businesses innovate not just with data, but around data privacy itself, making it a core value, something to mull over?
That's a really powerful thought to end on. Thank you for joining us on this deep dive.